Good afternoon, everyone. This is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on this week's Zoominar. On this week's Zoominar, we're in session number 4 of our new series entitled the QME Report Writing Master Class. And today we're in session 4, and I'm very, very excited to be with you here today. We have an extra special guest, one of whom I'm sure you're going to be very pleased and privileged to learn from today. And so I'm excited to share with you today's material. Now, let's put this in a little bit of perspective. We're in session 4 of our new series. It's entitled the QME Report Writing Master Class. And the whole purpose of this Zoominar series is to help you write better, more useful reports that can be better used by the parties who actually rely on your reports to bring disputed issues and these cases into a successful resolution. So what I want to share with you today is some ideas to further build on the foundation that we established through sessions 1 through 3, and share with you today the claims payers and the defense attorney's perspective on your report. And I'm sure you're going to learn some brand new and novel ideas that you have not heard before from me or from anywhere else. So I'm very, very excited, and I have a great presentation for you. Before we get started, just a little bit of admin. Today, we're talking about the high quality report, and we're talking today from the unique perspective of the parties that use our report and the parties that pay for our report. So we're talking about the claims payers and the defense attorney's perspective. Now, of course, we only have 1 hour together, so this is a bit of a superficial discussion, of course. But if you want more information, we have more information available for you. We have continuing education programs such as Slippery Slope and Super Sleuth, and we have an entire 6-hour program on apportionment. So if you want more information, we have these resources available for you. And then we also have the new QME Report Template available for you as well. And in the new QME Report Template, we have everything in that template that we've been talking about over the course of these 4 sessions, including what we're going to talk about in today's session. So if you're struggling with improving the content and quality of your reports, the wheel has already been invented, and we have this template if you need such a template. Okay? So that brings us to today's discussion. And today I want to introduce our special guest, Mr. Saul Allweiss, who is a defense and industry expert. He's been around since the beginning of time, or for decades, I should say, in California workers' compensation. And he's a very distinguished guest for us today. I'll just share with you a couple of his noteworthy accomplishments and credentials. He was a former claims examiner and hearing rep as a non-attorney, by the way. Began his career as a non-attorney with both Fremont Indemnity and also Republic Indemnity. Then he got his law degree and became the assistant vice president of home office claims for Republic Indemnity in and around 1994. Opened his own practice in 2002. And has received a couple of noteworthy awards, including Defense Attorney of the Year, and then also Workers' Compensation Professional of the Year. So these are high accolades, and I just share these with you to let you know that we're in the presence of a true expert today. And I can tell you how I met Mr. Allweiss. I met Mr. Allweiss, I think it was in early 2020 at the new medical legal fee schedule committee meetings. Mr. Allweiss was there, I was there, and I can tell you that Mr. Allweiss has as much to do with our current medical legal fee schedule as anyone, because in the room at the medical legal fee schedule meetings, he was there representing his client at the time was School's Insurance Company. And if you know anything about School's Insurance Company, they're one of the smaller insurers. And so my understanding is that they're much more sensitive to some of the fee structures and schedules that are prevailing in the industry. And Mr. Allweiss was a vocal and vehement arguer for the need for a new medical legal fee schedule, which we're now operating under. And in addition to that, I've sat with him on at least one QME report quality committee where, again, he was very vocal and very vehement about what needs to improve in order for the workers' compensation system to flow quicker, better, and more easily and more cost effectively to bring these cases to a resolution. So I'm really pleased and honored that he's decided to join us today. Okay, so before we begin today's discussion, let's just everyone give Mr. Allweiss a virtual round of applause, please. Okay, all right, and let's begin. So let's put this in perspective as we get started today. The whole need and the whole drive now for higher quality QME reports has to do with some trouble that landed on the desk of the DWC in late 2019. 2019, the state auditor issued her report following her investigation of some of the practices of the Division of Workers' Compensation. And specifically, the state auditor looked at QME reports, and she was quite disappointed because she found that approximately 85% of all QME reports are substandard in one or more ways. And substandard means that as they're written, they can't be used by the parties to resolve disputed issues. They can't be used to move cases forward. They're of no value. They're what's referred to as low quality reports because they do nothing to assist the forward movement of cases through the system. 85% is what she identified. Well, the problem with this, and this is what Mr. Allweiss is very, very sensitive to for himself and for his clients, is that low quality reports add expenses for employers involved in disputes. And schools insurance was very, very vocal about their escalating expenses due to low quality reports. She went on and she said that supplemental reports, depositions, and replacement panels all add time and expense to the resolution of the claim. So I just want to take a little aside right here and show you the state auditor's report. So we'll switch screens. We'll go to the state auditor's report here. I've included this for you in your handout materials, and you'll find the link to these in your chat. If it's not there, I'll get it there in just a couple minutes. So this is the official document from the auditor of the state of California, and it has an index, and there's a heading here halfway through the report that talks about how the DWC has failed to comply with state laws to ensure that QMEs produce high quality reports. So if we go to that section, here it is here. DWC has failed to comply. And here's the conclusions of the state auditor. She said that the DWC has not continuously reviewed, okay? I can tell you now that the DWC has been shaken up by this, that they are going to begin to continuously review our reports. But at the time, she said they have not continuously reviewed medical legal reports for quality and have not tracked when workers' compensation judges have rejected medical legal reports that failed to meet minimum standards. And I can tell you also that judges are now ramping up to identify more and more reports that fail to meet minimum standards. Well, this is a problem, and Mr. Allweiss will tell you this, is that the quality of these reports is especially important because reports that are inaccurate or incomplete can potentially delay resolution of disputes and the worker's receipt of benefits, both of which we don't want. And they can increase costs for employers involved in the disputes. And this leads directly to Mr. Allweiss's interest in having us as qualified medical evaluators produce better reports. Finally, state auditor said that low quality reports, these 85% of all reports that are circulating through the system, can delay injured workers' receipts of benefits and add expenses for employers involved in disputes. And she goes on to talk about all of the delays that these things cause, such as the need for supplemental reports, the need for a deposition, the need for a new panel. All of these scenarios add time and expense to the resolution of the claim. And that's the problem that low quality reports lead to. So in addressing low quality reports, the Division of Workers' Compensation assembled what they referred to as the report quality committees to study and to improve QME reports. That brings us to the point in time where we are today, where Mr. Allweiss and I were both on at least one committee together. And Mr. Allweiss is going to share with us now what he would like to see in our reports moving forward. Okay, Mr. Allweiss?
Yes, thank you, Dr. Carpenter. So when we talk about a high-quality medical QME report, we're talking about actually a report that in my mind should be minimum standards. So let's start with the beginning of the report. We have to have a detailed history of the injury. Specific injuries are a lot more easy to take a history of, but we want to know the mechanics of the injury and the body parts that were injured. So, if you could get a history from the applicant as I slipped and fell and I hurt my back, okay, that's understandable. But if the applicant's complaining about his wrist, we want to know, well, what were involved in the mechanics of the injury that caused the applicant to hit his wrist or hurt his wrist. Now, it might be a simple answer. He fell on his wrist when he hit his back. But if you just say the applicant reports wrist and back and you only take a hit mechanics of injury affecting the back, not knowing how the wrist got injured is a problem. CTs are more problematic because in a cumulative trauma injury, the applicant is going to maybe just say, well, I know my work caused this. Well, you want to get a history from the applicant as to what were the injured worker's job duties and how does the injured worker believe they caused his injury. Now, maybe the applicant may not understand that question, but you got to try to get a history from the applicant as to what he believes the workplace did. Now, come on, sometimes it's easy. He's involved in heavy labor, lifting tire rims all day in a wheel rim plant. Okay, I can understand how that could be a back injury, but the injured worker has to sit all day. How did the injured worker injure his back? And that's a question that we want to get the mechanics of the workplace. We also want to know about a medical history, and I want a complete medical history to the extent that it's relevant to the applicants to the evaluation that you're conducting. If it's a psychiatric evaluation, we probably want to know developmental history going back to childhood. If it's a back injury, we want to know did this guy play football in high school? We want to know, a medical history relevant to the injury that's presented. We also want a complete employment history. Again, get the applicant's description as to what he did at his current work, and also, if it's cumulative trauma, get a history of prior employment. CTs sometimes are, pled for 1 year, but, keep in mind, CT, and I don't want to get into too much detail on this, is a legal myth that we ascribe fault to the last year of employment if it's a cumulative trauma, but it's actually would be the applicant's entire career in whatever workplace environment he was involved in that contributed to the cumulative trauma. So give us, especially in a CT, a complete employment history. Activity of daily living, that's a really important part of our evaluation since we adopted the AMA guides. So please get get an accurate history from the applicant as to how this injury has impacted his activities of daily living. Obviously, we want a medical diagnosis that has, so absent causation, absent any type of issues relative to what was industrial cause versus non-industrial cause, what is your medical diagnosis as to what problems the applicant currently suffers from? And then, of course, in your discussion section, and we go on to the next slide, Dr. Carpenter.
Before we do, Mr. Allweiss, let me ask you, with regards to the activities of daily living assessment, how would you suggest that doctors mechanically go about doing that? There seems to be several different ways that doctors conduct their activities of daily living assessment. What would you suggest?
There are some forms online. I think the AMA guides actually have some suggestions on how to do it. That there is, there's no required format, but you definitely want to take an assessment of the impact of the activities of daily living and how they impacted your particular specialty as to the injury that the applicant had. So, I think the forms that the AMA provides or any other forms that you could find online are going to be probably appropriate.
Okay.
So, now comes the meat of the report. Causation. We want to know what, in terms of your medical diagnosis, how does that relate to the workplace? So again, let's get back to this specific. That's kind of easy. Slipped and fell, he hurt his back. But how, if the applicant slipped and fell, hurt his back, and he has wrist complaints, but he didn't land on his wrist, well, why would that have anything to do with causation with the workplace injury? If you believe it's a compensable consequence of the industrial injury, either because of treatment or because of what the applicant was engaged in, tell us that. But the causation should have a detailed discussion as to how and why. P&S, and this is a big issue for us. Permanent stationary or MMI. What is the applicant? What is his current status? And I know many doctors want to say, gee, if he only has 20 more sessions of physical therapy, I think he'll be MMI. Well, that might be appropriate if the evaluation might have occurred 6 months after the date of injury. But if we're more than 2 years down the road, I'd like you to perhaps consider that maybe, 2 more months of physical therapy is not necessarily going to help him. Maybe I'm wrong, and maybe you think it's essential. I don't want to, I don't want you to put my words in your mouth, but I want you to consider that. And then, but again, as far as P&S, how and why has to be addressed, and how and why is something that we're going to repeat many times. After you discuss causation and permanent stationary, the next question is permanent impairment. And since we are operating under the AMA guides, other than psychiatric impairments, and psychiatric impairments fall under the AMA guides, so we use something that isn't in the AMA guides to rate impairments. But other than psych, you have to quantify impairment utilizing the 5th edition of the AMA guides. The old work restrictions, for those of you who were around before the AMA guides, we could talk about work restrictions when in regards to the applicant's ability to return to work. But as far as impairment, you have to quantify impairment somehow utilizing the 5th edition of the AMA guides. So I guess we can go on to our next slide. After you talk about impairment, you have to talk about apportionment. And apportionment is, Labor Code Section 4663 and 4664. 4664 is pretty mechanical. If you're told that there was a prior award affecting the same body part, it's just a mechanical subtraction. But 4663 is more amorphous. And we have case law that defines Labor Code Section 4663 that says you can apportion to both pathology and asymptomatic conditions. The law prior to the enactment of SB 899 back in 2002 had a very vague definition of apportionment that, actually it was a definitive definition of apportionment, that it had to be symptomatic and disabling at the time of injury. And the amendments to Labor Code Section 4663 actually go the opposite way. And you can apportion to both asymptomatic conditions, you can also apportion to pathology. But you always have to give a discussion of how and why the apportionment in non-industrial was, and remember, we're talking about apportionment of permanent disability. We're not talking about apportionment of injury. We're only talking about apportionment of permanent disability.
So you can see that the recurring theme throughout all of these sections of our report that the claims payers and the defense attorneys identify as areas needing improvement, they all have to deal with providing opinions and conclusions that can be supported. It all has to do with the concept of substantial medical evidence. Now, I know many of you have heard this term. It's one of those buzz terms. It's one of those phrases that are sort of bantied about. And so we'll talk a little bit about that here. You remember the term substantial medical evidence. The word substantial is a takeoff on the word substance. So a substantial opinion is an opinion that has substance. And a substantial opinion is different from an opinion that lacks substance. An opinion that lacks substance is what's referred to as a conclusory opinion. So when you have a conclusory opinion, such as you need a new roof, right? The roofer comes to your house and he says, you need a new roof. That's the conclusory portion of the opinion. You as the homeowner are going to have a few questions for the roofer, and you're going to follow that up, and you're going to ask the roofer, well, why do you say that? Why do you say I need a new roof? You're looking for the substance to the opinion, and the parties are the same in reading our reports. It's one thing to offer conclusory opinions. It's entirely a different matter to offer an opinion that has substance that supports the conclusory portion of the opinion. Now, it's very, very interesting in the system that we work in. The players and the parties and the judges and the board, the appeals board, and the defense attorneys and the applicant attorneys, the players that use our reports, can only use opinions that are substantial opinions. They cannot use a conclusory opinion. A conclusory opinion does not rise to the level that it can be used in the system. It's very, very interesting. So you can satisfy the parties by providing substance for each and every opinion and conclusion that you offer in the body of your report. And let me share with you some ideas from these important cases as to exactly how to do that in the body of your report. So a couple of important cases that we talked about. We'll talk about Zemke, Garza, West, Granado, Bassett, and finally the big daddy of them all, Escobedo, which Attorney Allweiss will handle. But let's just go through the important principles of each of these cases. So Zemke tells us that the teaching principle is that an opinion that does not disclose its underlying basis and gives a bare legal conclusion does not constitute a substantial opinion that can be used to resolve disputed issues. Okay, so you must support your legal conclusion, your medical conclusion, with some substance. Garza says that any award, order, or decision of the board must be supported by substantial evidence in light of the medical record. And here's where this point is confirmed, that the parties cannot use the opinion if it's not supported by substantial evidence. So the parties are looking for a particular type of opinion from us as qualified medical evaluators. You know, it would be kind of like you looking across a basketball court and spotting across the basketball court a purple basketball. Okay, a purple basketball is a unique type of basketball that catches your eye. And similarly, substantial opinions can be readily identified by the parties and catches the eye of the parties because they're purple, because they're different, because they contain substance that supports the conclusory portion of the opinion. West told us that an expert opinion is no stronger, and we're experts. We're medical experts. So our medical expert opinion is no stronger than the facts upon which it is based. So the West case gives us a great clue as to how to add substance to our opinion. It has to do with the facts, with citing the facts, with providing the facts, with explaining the facts, and using those facts to create a purple opinion, a substantial opinion that the parties can then use. Granado says a mere legal conclusion, in our circumstance, a mere medical conclusion, does not form a basis for a finding. Imagine the roofer comes to your front door and after conducting a roofing inspection, and he gives you a bare roofing conclusion. He says, you need a new roof. What are you going to do? You're going to go, oh my God, I need a new roof. Are you kidding me? You're going to say, upon what basis do you conclude that I need a new roof? You're going to ask the roofer for the basis of his finding. And so you can phrase this in the body of your report. When you offer an opinion or conclusion, you can simply say, my basis for saying this is colon, and then list several bases that support your conclusion. Finally, the Bassett case gives us some great insight into constructing substantial opinions and conclusions. It says the chief value of an expert's testimony rests upon the material from which his or her opinion is fashioned and the reasoning, keyword reasoning, I put it in yellow to catch your attention, the reasoning by which he progresses from the material to the conclusion. So you must show your reasons as to how you arrive at your conclusion. It does not lie in the mere expression of the conclusion. You need a new roof. Okay? You need a new roof. Thus, the opinion of the expert is no better than the reasons upon which it's based. And I've highlighted this word reasons, and we're going to use this word reasons in supporting each and every one of our opinions and conclusions. And I'll show you exactly how to do that in just a couple moments. Attorney Allweiss, can you build on this and talk about Escobedo?
Yeah, so in 2005 or 2006, Escobedo came out. And Escobedo is a case that, turned on the issue of apportionment, but it also had some very good rules of the road in regard to how, what is substantial medical evidence. And they talk about substantial medical evidence is, you can't rely on facts that are no longer germane. You can't rely on an adequate medical history. You can't rely on the incorrect legal theories or surmise, speculate, conjecture, or guess. It has to discuss, and also it's not just the physician's opinion. The doctor has to have reasons behind his opinion. So when we talk about Escobedo, hammers home the point in any of your opinions regarding causation, regarding permanent disability, regarding apportionment. You have to discuss how and why. And I want to digress just for a second. Many doctors say, well, can we get feedback from the parties as to, was my report substantial evidence? And the answer is, well, it's kind of difficult to the extent that while the case is pending, none of the parties can give you feedback as to whether we believe your report is adequate. In many cases, actually most cases, I think, roughly 90-95% of cases, they're settled. Now, sometimes I settle a case because the Qme report was great. It was substantial evidence. Everything was perfect. I was able to settle a case on that. Sometimes I settle the case on the Qme report that it's not perfect. But then I have to sit down and scratch my head to say, what was the doctor trying to say? I have to put in my own projections and try to convince my opponent as to why my projections are right. And you can see how that becomes a pretty slippery slope. Sadly, I can't, until the case settles, I'm prohibited from contacting the parties. And then after the case settles, many times my client doesn't want me to contact the doctor about a bad report, to the extent that they're afraid that we might get punished the next time the doctor is chosen. So I admit it's a flawed system. I mean, I had a harebrained idea, but there's lots of reasons why this was a bad idea. But, my harebrained idea was, well, why don't we do what I call was an outcome-based fee schedule, that we pay the QME a bonus, that if the case settles or there's a findings and award without the need for a supplemental report or a deposition, that the defendant pay the doctor a bonus. Now, there's all types of problems with that. So please don't run say, well, Saul said we're going to pay the doctors a bonus. That's not what I'm suggesting. I'm just suggesting that conceptually, I wish we could build something into the system that could do that. Unfortunately, there's lots of flaws with that problem that I don't want to go into. But let's talk about, let's go on, to the next slide, because we're going to talk about, where is substantial medical evidence required? Well, clearly it's required in the causation discussion, especially for those of you who practice internal medicine. I mean, really in that area, we really need your opinions as to what is the causation of this person's hypertension or diabetes relative to their workplace injury. And many times this may not be the workplace injury, it might be the compensable consequences of the workplace injury, but we need substantial medical evidence to support your conclusions regarding causation. So once again, very simple if it's a slip and fall and a lumbar spine strain, but if it's valley fever, and the person was outside for industrial reasons and non-industrial reasons, that's a real tricky causation question. And in all circumstances, again, in the simple ones, how and why might be very readily apparent, but sometimes it could be very deceptive, such as in the valley fever discussion. And psych is a whole nother area that we won't get into today. In terms of permanent impairment, I'm sure all of you guys have heard the words Alvarez-Guzman. Well, Alvarez-Guzman is a Court of Appeals case, and it addresses the AMA guides. And it says that a doctor can rate by analogy so long as he stays within the four corners of the AMA guides. Now, some applicants' attorneys will say that that includes the forward page and the dedication page and the last page of the definition. But I'll suggest that they're really referring to the substance of the guides. But the Alvarez-Guzman case also provides a very, very detailed discussion as to how you do, how you can go past a strict impairment. And also, it's used in discussions regarding apportionment. But let's first talk about Alvarez-Guzman. So in the next slide, here, this is the very, very detailed step-by-step analysis of how you do an Alvarez-Guzman approach. The first step is, and many QMEs forget this, you have to provide the strict or standard impairment rating. So, if we're talking about somebody that presents with, it's a hand injury and you want to rate grip, many doctors just jump to the grip. Well, if those of you who are orthopedics or chiropractors should know that the AMA guides frowns on the use of grip unless there's a separate pathomechanical causation of the impairment. But that doesn't mean that you're precluded from using grip. What you have to do, though, is for a hand injury, you have to first do the strict impairment rating, which is probably going to be doing range of motion, and seeing if there's any nerve involvement, and providing that, that strict analysis. Then you have to say, okay, I've done the strict analysis. Now I don't think that accurately reflects the applicant's impairment. Now, once you presented that rationale, how and why, that the applicant's actual impairment is not reflected in the strict under the strict rating, then you can do the alternate rating. That's when, for our injured worker with the grip loss, you can do the grip loss even if there is no separate pathomechanical impact causation of the injury. So, many doctors, will, immediately, some of the more wild Alvarez Guzmans that I see out there is, well, it's a back injury, but the applicant has lost conditioning, and therefore I'm going to analogize by using the pulmonary function chart in terms of loss of METs, his ability to exercise, and use that chart. Well, technically, that's an alternative rating within the four corners of the guides, but I'd like to suggest that when you try to explain that being a more accurate way of impairment, that to me is going to be a stretch, and especially if you don't do the strict rating, then your impairment rating of analogy in that circumstance is just not going to be taken seriously, and it's not going to be relied on. And step 4, when you do your alternate rating, you have to once again tell us, how and why this other rating more accurately reflects the applicant's actual impairment. And by the way, you can't just go back to work restrictions. Work restrictions are not in the AMA guides, so you just can't say, and because the applicant's range of motion or DRE for the back doesn't accurately reflect his impairment, so I'm going to give him a sedentary work restriction. No, that's not going to work, because the old work restrictions that we utilized before 2002, that is not part of the AMA guides. Okay. Now, another alternative rating is what's known as the kite formula. The combined value charts is, that's part of the AMA guides, and it says that you shall combine impairments. And as you know, the CVC, says, 10 plus 10 does not necessarily equal 10. 10 plus 10 might equal 18. And the higher you go, the impact of the CVCs become more severe. So when you get to 70% impaired, 70 and 40, well, that isn't going to be 110. In effect, it's probably going to be somewhere around 80. And it's, and technically using this CVC, it's almost impossible to get to 100. So as you could utilize an alternative rating under kite, because chapter 2 of the guides does say that you don't have to use the combined value charts. You can add impairments. It actually says you can multiply impairments. I've never seen that done, thankfully, from the defense perspective. But you can add impairments, and when you can, but first do the standard rating, and then say why the standard rating is under the CVC does not accurately reflect the applicant's actual combined impairment, and then say, well, you know what, adding them does more accurately reflect it. The magic words that people like to use are synergistic effect. I bristle when I see that. I want you to once again describe for me how and why. Why these impairments don't overlap, because CVC wants to say, well, look, impairments are, they overlap one another, so therefore we shouldn't combine them. We shouldn't add them. We should combine them. And in most instances, I would like to suggest the combined value chart probably does accurately reflect the actual impairment. And I think when a person has bilateral upper extremity or lower extremity injuries, I can see how impairments, might have to be considered to be added. I don't think it has to happen in every circumstances, but when you have, a neck disability and a leg impairment, arising from the same injury, I'd like to suggest that that's harder to show. The synergistic, or the fact that there's absolutely no overlap of the impairment values means that you should add them. I think that in many instances, just saying the magic words kite and synergistic effect aren't going to get you there. Once again, you have to do an analysis as to how and why.
Okay. So let's show how this would look within the body of the report. For example, an alternative impairment rating within the body of the report. So, for example, in the permanent impairment section of your report, you would set that up in standard fashion. You would provide the questions from the parties' cover letters, applicant attorney questions, defense attorney questions. And then you would set about the process of answering those questions. And here I have an example for you related to, let's say, for example, a lower extremity impairment. So you tell us that, in my opinion, Mr. Smith qualifies for impairment of the right lower extremity as follows. And then you take us through every single one of the impairments that are described in Chapter 17, and you let us know if he either has that impairment or he does not have that impairment. And in this example, I suggest that he does not have an impairment due to gait derangement, but see the alternative impairment rating below. Under the strict application, he does, however, have an impairment related to meniscectomies. So this is just an example for illustration purposes. It says that this guy qualifies for an impairment due to partial medial and partial lateral meniscectomy at 4% whole person impairment. His total impairment is 4% based on partial medial and lateral meniscectomy. So there's your impairment rating under the strict application of the AMA guides. Now below that, once you have that established, that's where you can entertain the idea of an alternative impairment rating under Alvarez and Guzman. And here's where you would put generally the applicant attorney's question on this. This is going to be coming to you more from the applicant attorney, but also if the defense has a question about Alvarez Guzman, put it here. Put it here. And then here's where you embark on the 4-step Saul Allweiss formula here to substantiate your opinion for an alternative rating. You say, in my opinion, Mr. Smith qualifies for an alternative impairment rating as the most accurate description of his left lower extremity impairment as follows. And here's step number 1 is to give us the strict rating. So it says the strict rating, his impairment under the strict application of the guides is 4% due to partial medial and lateral meniscectomies. Boom, you've checked that box. Okay, that's an easy box to check, right? Then a little bit harder box is to tell us why the strict rating is not accurate. And this is just an example. I just made up a bunch of stuff here where I explained that, the rating due to partial medial and lateral meniscectomy, in my opinion, is not accurate. And you would fill in your reasoning here in this area. In this example, I just give several sample reasons. Then step number 3 is to give us the alternative impairment rating. So here I say, in my opinion, his right lower extremity impairment is most accurately, key phrase, most accurately, is most accurately described under table 17.5 as a mild gait derangement at 15% whole person impairment. Step 3 is a fairly easy step. So it's interesting. Of the 4-step formula, give the strict, explain why it's not accurate, give the alternative rating, explain why the alternative rating is accurate. Steps 1 and 3, those are the easy steps. Those are the conclusory steps. It's steps 2 and 4 that are the harder steps. Those are the steps that add the substance. Those are the steps that make steps 1 and your opinions in steps 1 and 3 substantial opinions. Now, here's where the rubber meets the road. If you cannot provide good reasons under step number 2 and step number 4, guess what? The reason that you're not able to do that is because the alternative impairment rating is not the most accurate rating. When it is the most accurate rating, you'll be able to easily complete steps number 2 and steps number 4. So this is how you can test yourself. But excuse me. If you're not able to come up with those reasons, then don't go forward with the opinion for an alternative impairment rating. And when you give your reasons, the more voluminous and the more compelling are your reasons, with emphasis on the word compelling. Compelling trumps voluminous, but in general, you want to have compelling and voluminous support for your alternative impairment rating. If you can do that, you can feel confident and assured that the alternative impairment rating that you provided is indeed the most accurate rating. So that's how you would handle that. Let's talk about how to handle apportionment.
Okay, well, apportionment, once again, we established an apportionment, it changed under SB 899. And your apportionment discussion is really a 2 or potentially 3-step process. So the first portion of your apportionment analysis is to first describe what portion of the applicant's permanent disability was directly caused by the industrial injury. And so, don't start your discussion by talking about the non-industrial factors. Start your discussion by talking about what are the industrial factors, what directly was caused by the industrial injury. Then you could provide discussion as to what portion was non-industrial. Now, again, how and why has to apply, and you can apportion to pathology and asymptomatic conditions. And I'll give you a perfect example of apportionment before and after SB 899. So you have a bank teller that is held up at gunpoint, and they have a massive heart attack. And when he goes through his four-way bypass, they find out that he was 95% occluded. Under the prior case law, the prior permanent disability had to be both symptomatic and disabling. So even though this person was 95% occluded, because he had no heart symptoms before he was being held up at gunpoint, defendants were unable to get any apportionment of permanent disability. But under SB 899, and as clarified in Marshall, Escobedo v. Marshalls, it does say that you can apportion to prior impairment, that is, and you can also apportion to pathology and asymptomatic conditions. So let's talk about our bank teller. Well, now we find out, under SB 899, I'd like to suggest that this bank teller who was 95% occluded, I don't know if you necessarily find the applicant to have 95% non-industrial causation, but I believe that you can find a significant portion of the fact pattern that I just described to you to be non-industrial. But that would also apply to, somebody that had a back injury that had very significant advanced arthritic findings in the spine. So yes, the back injury, the slip and fall incident, had some direct causation of permanent impairment, but the fact that this person might be 60 years old and has advanced arthritic changes, well, that's underlying pathology that might have been symptomatic, might not have been symptomatic. So, and you could do this, utilizing, various methodologies. But the last discussion of apportionment, is if there's multiple dates of injury, we want you to apportion between those multiple dates of injury. Most commonly, there's maybe a specific and a CT. There might be multiple specific injuries. There might be multiple CTs. We ask you as the evaluators to give us your best medical opinion as to what you believe is the apportionment between the multiple injuries. So first, what was directly caused by the industrial injury, then what portion was non-industrial, then lastly, go back to what was directly caused by the industrial injury, and if there's multiple dates of injuries, provide us an apportionment between the multiple dates of injuries. So, I mean, here's, you have, just a hands-on discussion. You first discussed, what portion of the applicant's permanent disability was directly caused by the industrial injury, but then you want to put in the apportionment discussion. And part of those conclusions that you are relying on for non-industrial causation, might be osteoarthritic condition. It might be the fact on x-rays there's degeneration, and this was a relatively benign specific event. Let's say it's a knee injury and it's a relatively minor knee injury, but on x-rays there's significant degeneration in the knee. Okay, well, that's that could be a factor of apportionment. So that is, it could be, based upon a history of automobile accidents. It could be the fact that he was a football player in high school, and had and sustained trauma over all those periods of time. So everything that you got from his history, everything that you got from the diagnostics, those could all be factors that you can use for support of apportionment of permanent disability to non-industrial causation. And we talked about these already. The mechanics of injury, I think, is very important because many times it's a relatively benign injury. Well, if that's the case, that first discussion point as to what portion of the applicant's permanent disability was directly caused by the industrial injury, well, it might be fairly nominal. That if you believe the applicant had, it's a DRE3 and he's got 18% whole person impairment, but it was a lifting incident that didn't involve any, significant trauma, well, maybe you might have to conclude that only 5 or 10 or 15% might be directly caused by this relatively benign event. But then you have to provide support for the opposite argument, and that is why this relatively benign lifting event the applicant has this much impairment, and the benign lifting event only was responsible for 10 or 15%. Well, now you have to provide discussion as to why the 85 to 90% was non-industrial. And you can, base it upon the mechanics of injury. You can base it upon the applicant's job duties. You can base it upon pre-existing conditions, prior industrial injuries, or diagnostic studies. Once again, when you go back to, if you take a good history of the injury and a good medical history, hopefully that's going to give you all of your factors relative to causation of permanent disability that was industrial, directly caused by the industrial injury, and what was non-industrial. Now, you can't use speculation, but you can give approximate percentages. Every now and then I cross-examine a doctor that isn't in workers' comp, and he says, so you want me to give me an approximate percentage of what permanent disability was industrial versus non-industrial? And they laugh at me, and okay, I'll tell you, you're right. Okay. We are, having to put a number on this. I'll be the first one to admit, in reality, it's very difficult to do, but we need for you to do this. Why? Because most workers' compensation cases are settled. So if you tell me that 25%, 30%, 40% was non-industrial, and tell me why, that there's a degenerative problem, that there's the mechanics of injury are benign, but he's old, or things of that nature. If you could just justify your rationale as to why the approximate percentage of the permanent disability was non-industrial versus industrial, I can live with that because I can settle that case. Again, most cases are settled. Most cases are not decided by a judge. All right. Well, Dr. Carpenter wanted me to give you a wish list, and I see we only have a couple minutes left, and there was one question in the chat that I wanted to answer. many times, you're going to see an applicant, a couple years after the injury occurred. And you're going to say, you know what, if he only had 12 more sessions of physical therapy. Well, look at my cover letter. I'm going to tell you whether or not the case is admitted or denied. If it's a denied case, I'm going to I'll tell you that. And then if you're saying he needs 6 more weeks of physical therapy, well, if the case is denied, my client's not going to be authorizing that 6 weeks of physical therapy. So, could you give me an impairment analysis, even if you don't believe the applicant's MMI? And if you've seen the applicant on 2 or 3 occasions and the treatment recommendations that you've been making have not been followed, well, take that as a cue. Maybe you are, or IMR has denied those treatments. And once again, and I can't speak for my colleagues or opponents, I try to tell you in my letter, I know that you requested that the applicant undergo back surgery. I'll tell you that UR is non-certified. Well, if that's the case, then please take that as a hint. Maybe this guy should be called MMI. Once again, there's only 104 weeks of temporary disability that my clients are legally obligated to pay on 95% of our claims. There's just a few exceptions to that. So the applicant wants you to write an MMI report because they want to settle their case. So, if you can pick up on my cover letter, I think that you will find that I will give you hints as to why I'm getting a little frustrated, and I want you to find the applicant MMI. Also, another wish list thing is, at least in my cover letters, I will tell you that I'll authorize diagnostic tests. They can be completed in your offices on the same day as your evaluation. And if you need additional diagnostic tests, I'll give you the name and phone number and email address for my clients so they could be arranged. If these could be done before the eval, and I know many times you don't get our letters until the last minute, and that's part of the problem with the process, and sometimes it's the parties. And I know sometimes you just get stock cover letters that really don't mean anything. But hopefully in my letters, you're going to pick up on what I want you to do and what type of diagnostics tests I want you to conduct. And if you can get them done on the date of your eval or even before the eval so that we don't have to get a supplemental report, that would be great. Dr. Carpenter, there was one question that got in the chat that I think is worthy of addressing, that some doctors are getting exactly 200 pages of documents and that's it. Okay. That's a defense person that is trying to take advantage of the new medical legal fee schedule, because the new medical legal fee schedule says that the flat fee is what is paid if there's only 200 pages of documents, and anything more gets paid at the rate of $3 a page. I will be, and I was on the committee that formed this new fee schedule. The new fee schedule is horribly flawed. And it's horribly flawed for a lot of reasons. I think the most significant reason is that, we were trying to cure the problem of the hourly billing. So I used to call them, and I know none of the doctors attending this seminar did this, but I had the dyslexic doctors that read at incredibly slow rates. And I got these astronomical bills for the review of medical records. So now we limit it to the number of pages, but now that cuts the other way. Where the applicant is examined multiple times at Kaiser, and most of you guys know that a Kaiser on the job medical appointment is sometimes 35-page long, but really there's only around 1 or 2 pages that are really relevant. Well, okay, technically the doctor can bill for 35 pages times 100 visits and get compensated more, but this is a flaw in the system. That somebody's that's sending out, I'll tell you, just because I'll speak my own mind, I'm not speaking for any of my clients. If somebody sends you exactly 200 pages, I think that they're taking advantage of the system from the defensive perspective, and it's a bad practice. But I'll throw it back on the QMEs. If you get duplicate sets of records, and the duplicate set of records, yes, you can bill me for 2 times 5,000 pages, but do you have to? And you guys might say, well, in the aggregate, you have to. I'll just give you an anecdote that I think, just before I had a massive case. The applicant had multiple back surgeries to every part of her body from an injury back in 2012. And literally, without historical records, just treatment records were 25,000 pages. And the exam had to be rescheduled a few times because she had 2 more shoulder surgeries, after going through like 14 more procedures on literally every part of her body. And I called up this doctor's office, very reputable AME down here in the South. And I said, look, I know the new fee schedule is in effect. I'm sending you 25,000 pages of documents. I really would ask that the doctor bill me under the old fee schedule, because I knew that she would not take advantage of it. And sure enough, I got a bill for $12,000, which I think more than compensated her for this evaluation. But under the new fee schedule, she could have billed me $75,000 for it. And I'm not saying that you guys should do that. I'm just saying that just gives you an interesting anecdote as to, I think that our mechanical way of just counting pages is flawed, and we're going to have to take another look at it.
Okay, Mr. Allweiss, I think we have a couple of questions, and then we'll conclude because I know you have another appointment. One doctor says, since the new fee schedule, we're increasingly being asked to submit reports without having the medical records or only a fraction of that, and we all know that this happens all the time. What's your opinion on the examiner's ability to achieve substantial medical evidence in such a case, and how should the Qme handle this? And this is a problem. You know this. We all know this. Reports come in disjointed segments, late, overdue. What do you suggest?
You do what you can with what you have. I mean, if you're getting nothing, I can understand why you feel that all you could do is take a history from the applicant and provide diagnosis, and maybe you can't even provide an opinion on causation. I can appreciate that when you get nothing. But on the other extreme, I have a Qme that I asked for a supplemental report from, and he said, well, you did, and I didn't ask, I was just interrogatory, I didn't submit any additional pages. Well, you didn't submit a declaration for the 1-page letter that I sent to him. Okay, so that's 2 extremes. But I can appreciate the physician that asked the question. What am I supposed to do? You do the best you can with what you have.
Okay, we're running late. Mr. Allweiss, I'll give you first crack at closing comments.
Well, I'd like to thank you, Dr. Carpenter, for asking me to participate in this program. I hope that it's helped train the doctors that attended. Fortunately, because you chose to attend, that shows that you have an interest in producing quality reports. So probably the message that you and I are trying to present is not reaching the doctors that need this the most. But that's not, I can't do anything about that. But thank you for asking me to participate.
Okay, so in conclusion, everybody, let's thank Mr. Allweiss for joining us here today. So the bottom line take-home message that you're getting over the course of these 4 sessions, at least regarding this program, is that there's probably 100 different ways that we can improve the content and quality of our reports. And some of those ways are more important than some of the other ways. Well, probably one of the greatest single changes that we can make to our reporting to improve the usability of our reports by the parties who actually rely on the opinions and conclusions in our reports is to support each and every opinion with substantial medical evidence. And in today's session, we gave you several examples as to how you can support each and every opinion. The basic way to do such is to provide reasons for every single opinion and conclusion that you offer in the body of your report. And if you can do that, you can garner for yourself a reputation as being a competent and qualified medical evaluator. And you can capture the lion's share of cases as the parties realize that you are a qualified medical evaluator who can successfully bring this case to a resolution. So doctors, I want to thank you for taking the time to join me on this week's Zoominar. Look forward to being with you on future Zoominars as well. And for now, I want to thank you for your commitment to excellence. I want to thank you for your dedication to continuous learning. And I want to thank you for your personal contribution to improving the integrity of the Qualified Medical Evaluator Program. On behalf of Defense Attorney Saul Allweiss, this is Dr. Perry Carpenter, wishing you best of success in your career as a Qualified Medical Evaluator.
Thanks for asking me to participate, Doctor.
Thank you very much. Bye, everybody.